Good morning. It's 9 o'clock, so we're gonna start. It's wonderful to be with all of you. Good morning. It's good to hear from all of you. Good morning. And I actually see, it's wonderful because I see some faces that I met yesterday, but I also see some new faces. So welcome. This is actually one of my favorite times of the year where students come in and I get to meet all of you. And it's wonderful to have this space this morning to talk a little bit about success strategies and also studying techniques. And I also wanted to let you know that this is a space where you can ask any questions you have. I mean, the objective of organizing these orientation sessions is that you have comfortable spaces to make sure that you start acclimating, to the way we teach at the law school, and also studying techniques, and also specific steps that you can take to have good grades, also to do well and to absorb as much as possible from this academic experience as well. So I just wanted to tell you a few things before we actually start. One of them is that you can actually ask any question you have, and you can actually write them down in the chat function. I will be monitoring the chat function. So if you have any questions, please feel free to add them to the chat and I'll call on you. I will also give you opportunities to participate in the workshop. It's not going to be just me lecturing. I'm also going to be asking questions. And I always tell students when they start that it is a good idea to start getting used to speaking in the classroom. Class participation is extremely important at the law school. This is something that we really encourage. This is important for you, especially to develop your oral advocacy skills as an attorney. And also, it's very good for your grades. Most classes give you credit for that participation. So it is a good idea to start getting used to participating in class, even though it can be absolutely terrifying. I'm not a native speaker of English. I always tell this to my students, and I went through the US educational system as not a native speaker, and I remember how terrifying it was for me to speak in class. But what I learned is that the more I did it, the more comfortable I became, So it is a good idea to use opportunities like this to start getting comfortable. And remember, at the end of the day, it doesn't have to be perfect, right? Focus more on clarity rather than perfection. Remember, this is law school. You're learning how to do this, right? So it does not have to be perfect, but the important thing is that you do stay engaged in your classes. It's something that is very important for you to do. A few other things about today. We are recording this session. I just want to make sure that all of you know that. And we are going to go until 10 o'clock. I will give you a 5-minute break so that you stretch a little bit, and then we will go until 11 o'clock as well. Okay, so I'm going to pull a PowerPoint, and welcome again. It's wonderful to see all of you in this capacity, even though it's in Zoom, but I'm very much looking forward to next week where I start my fundamental section and I will see all of you in person, which will be wonderful, actually. So let me just pull my PowerPoint and we'll talk a little bit about what we're going to be focusing on today, okay? We're going to be discussing a few topics today. One of them is I'm going to give you some tips of how to read cases. And at the beginning of your law school journey, that's probably one of the most challenging and intimidating components of what you're going to be doing. You're going to have to read a lot of cases in your classes. This is a common law system. It is based on precedent, or what we call stare decisis. This is something that we're going to be discussing in fundamental issues in US law. So you will have to read a handful of cases for most of your classes. And the beginning of reading cases can be very daunting. It can be very different, especially for those of you that come from civil code jurisdictions, but it is something that you can master. It's something that you can get great at. And I'm going to give you some tips, especially of how to handle that beginning of the semester where you start reading cases. For example, next week, we some of the classes like fundamental issues in US law, but also some of the 1L classes, what to do, especially at the beginning. But it does get better, and I promise you that. We're also going to talk about case briefing and outlining, which are major studying techniques at the law school. And these have been tried and tested for many years. Even when I was in law school 20 years ago, I did case briefing and outlining. And many of the most successful law students do case briefing and outlining. And they're important not only because they're studying techniques, but they also train you to think like a US lawyer. And a lot of what we're going to be asking you to do in those final exams is really think like a US lawyer, apply legal issues to fact patterns as a US lawyer. So the process that you use to summarize a case, the process that you use to summarize, the legal issues and cases that you discuss in classes, sometimes it's equally as important, as actually knowing those rules and how to apply them, etc. So process is very important, and it's something that I want to highlight with you today. We're also going to be talking about plagiarism. Plagiarism is a major issue, something that for us is a very, very big deal. It can result in your suspension from the law school and many other penalties. So we will discuss a little bit about our policies on plagiarism. We're also going to discuss a little bit on research paper writing. Some of you are going to be taking courses related to research papers, and a requirement for LLM students to graduate is an 8,000 word paper in most of the specialties that we have. Some of you probably come from schooling in which you have actually written a lot of research papers, but some of you probably may not have written research papers, or at least you haven't done it in the way that we will expect you to do it in law school. So I will cover a little bit of that as well. And of course, along the way, I will also give you tips of how to study at law school and how to succeed in your classes as well, okay? So first, I wanna actually give you some case reading tips. I always tell students, when you first tackle a case, the temptation is to actually just read it once and try to get everything from it once. It's very difficult to do that, especially when you're starting law school, especially when you're starting in a common law system. Cases can be very complex. Sometimes they're not even very clearly written, There's a lot of cumbersome language, and we're gonna be asking you to absorb many different aspects of cases. And it's a good idea, especially at the beginning, especially those first few cases. For example, when we do fundamental issues in US law next week, it is a good idea. And it's actually, I would say, even more constructive to do several readings of cases. I suggest here 4, but it doesn't have to be 4. It can be 2 or 3, just for those first few cases. And I think in the first read, one of the most important things about a case is to try to figure out what the story is, what the issue is. Why do we really have a case, or this fact pattern or the set of events before US courts? Try to at least focus on that story. Try to, for example, try to digest it and be able to explain it in 2 sentences or 3 sentences, because that's something that you're gonna have to do in many of your classes. I also recommend that you do a second read, but in that second read, you don't focus so much on the story. You actually focus more on the holding, which is the conclusion of a case or what the court actually decided on a case, the legal decision of a case, and rationale, which is the process or the legal analysis that the court actually advanced to be able to reach that particular holding. I also would do a third read to focus more on that rule or what we call the legal question of the case. This is very important because when you're doing your final exams later in the semester, a lot of what you're going to be doing is basically absorbing those rules from cases and applying them to new fact patterns, because that's what we do as US lawyers. When you are a US lawyer, for example, you will receive a client in your office and the client will say, I had all these things happen to me, they will have a storyline, and you will advise that client on how the law, basically the law that's in vigor at the time, applies to that specific fact pattern, legal issues that could come up in that fact pattern. That's a lot of what you do as a US lawyer. So that's what we're going to be asking you to do in exams. We're going to give you a fact pattern, most of the classes, and we're going to ask you to apply all the legal questions and issues, and cases that you actually discuss in that class to that new fact pattern. So it's a good idea to start training yourself to actually absorb that rule from specific cases. In terms of the fourth read, if you do have time to do a fourth read, you can focus on the case as a whole. You know, you can actually read the case again and kind of see if you can actually capture all the different components. And I think this is particularly important, especially when you are reading those older cases. You know, when we do fundamental issues in US law next week, we actually have a combination of very old cases, which are kind of like the more classical cases. And then we have newer cases, you know, cases that the Supreme Court ruled, you know, in 2020, for example. You know, and you will see a very important difference in the writing style. You know, the more recent cases are a little bit more clear, they're easier to understand to a certain extent. Some of the older cases like Marbury versus Madison, Baker v. Carr, and so on, that we will be discussing next week, they can be very cumbersome to understand, you know. So it is a good idea to kind of divide or strategize in terms of how you read a case, especially when you're first getting used to reading cases as well. Any questions on this in particular before I actually move on to case briefing? Any questions? Anybody see anything in the chat? No, we don't have any questions so far? Okay, so let's go to case briefing. So case briefing is actually a studying technique that you will use mostly to basically inform or train yourself or prepare for class participation. We have a vast array of professors at the law school, and many of them use different styles of participation. You have the classical method, what we call the Socratic method, in which professors call on students in the middle of class, and students don't necessarily know that they're going to be called on that day. Or students, for example, could do bench participation. The students know, you know, they pick 4 or 5 students that know that that day they're going to be called on in class, you know, or professors, for example, sometimes seek volunteers, you know, they seek volunteers, you know, to volunteer for class participation. The idea of having case briefs is that it helps you be prepared for that class participation. And it's good to have a number of components in those case briefs. I mean, basically it's a summary of the cases that you're going to be reviewing in each class. I outline in the slide a number of components, but case briefs, you can have different styles. You know, you do have to find something that works for you as a student. For example, in my particular case, having very lengthy case briefs didn't help me because I kind of got lost in the information. For me, it was better to have them a little bit more summarized. But for other students, they really would love to have all that detail, you know, and I think it's really good practice because it gets you in the habit of training yourself to actually read a case and absorb the different components of it. So in terms of components, I include some in the slide. For example, title, facts, procedural history, issue or legal question. You know, sometimes we call this the legal issue or the legal question that the court is trying to answer in the case. I think sometimes when you frame it in terms of legal question, it's a little bit more clear at the beginning. The holding, which is that final decision of the case, and the rationale and reasoning, which is probably the most important part of the case. Sometimes the most important part of the case is not the way it was decided, it's the way the court got there. You know, the process that the court used to decide it and the rule. I say that this is probably the most important also part of the case because it's the legal principle. It's what you're going to be applying for, you know, future fact patterns or when a client comes to see you. You know, this is the rule you need to be aware of that you're going to be applying for future fact patterns as well. And I wanted to give you some examples of what a case brief looks like, but I also wanted to give you an opportunity to participate. And I just want to make sure that I'm seeing the chat here so that you can actually participate. I'm going to set this up again so I can see the chat. And I just want to make sure that some of you have the opportunity to participate in this segment of the workshop. Can you hear me okay? Anyone want to tell me what the facts are for the Asahi Metal Industry Company versus Superior Court of California case that we're discussing this morning? And no
Can you
fear,
repeat the question? Sorry.
the facts. Anybody want to tell me the facts of the case that you had assigned to read for today? No fear. This is a comfortable zone. You don't have to be perfect. The idea is to start getting you used to participating, because this is something that you're going to have to do in a lot of classes, and it actually helps you for your final grade as well. I see Tambi's high hand raised. So Tambi.
Hi. Zucker actually had initiated a product liability action because in 1978 he met with a motorcycle accident where he was injured and his wife was killed. So he had initiated this product liability action, claiming or alleging that the motorcycle tire, tube, and the sealant were defective. And he had then filed this case against a Taiwanese manufacturer of the tube. And also there were Asahi Metals was the, I think, valve manufacturer of inside the tube valve manufacturer, or tubes valve assembly. So I think
Tambi, that's a great summary. Actually, you've done an excellent job summarizing this case. And I really also commend you for being the first one to speak, because that's always very nerve-wracking as well. So I want to go over some of the facts so you can get an example of what you can include in a case, but I think Tambi did a wonderful job summarizing the facts in this case, okay? So we have, I'm going to show you. We have Zucker here had a motorcycle accident, as Tambi indicated. His wife was killed and he was injured. And he claimed basically before the court that he had an accident due to a defective tire, tube, and sealant. And as Tambi indicated, he presented a product liability action, which basically means a lawsuit against the manufacturer, you know, and others in the manufacturing chain. I mean, one thing that is very interesting in this case is that you have a number of defendants, you know, and those defendants, most of them were foreign-based companies, they were not necessarily physically present in California, you know, so this is why it becomes matter in many ways, or a territorial jurisdiction matter, because they're all based outside of the United States. You have a number of cross complaints that are filed in this case. I mean, this is a case that in the lower court level, it had kind of like an intricate and complex procedural history, which basically signifies that Asahi ends up being, you know, the only defendant, especially when the case, you know, reaches, you know, the higher court level, especially when it reaches the Supreme Court level in California, and then it reaches the United States Supreme Court as well. Any of you want to try telling me what the procedural history of this case is? Because that's actually a very important component of the case brief. What happened to this case? You know, where was it first filed? You know, what were the different levels? You know, anybody want to tell me? Somebody other than Tambi, because Tambi was amazing on the facts, but I want to make sure that we have the opportunity for other students to participate as well. If not, maybe I should call on somebody. I see Davron. You want to try the procedural history, Davron?
So I can go.
Okay, thank you, Hiwa. I'm very appreciative of that.
Okay, so the history, the two cases almost similar that happened in different years. The first one is in 1878, where Court of Mississippi couldn't exercise This is what you mean, right?
Well, procedural history is actually the process that the case took in the state courts, and then why do we have this case before the United States Supreme Court? Where was it first filed?
First filed, you mean, I'm sorry, I didn't get what you mean. Sorry.
Oh, that's okay. That's okay. Tambi, do you want to help?
Yes, so it was first filed at the Superior Court.
Yes. It was first filed at the Superior Court of California, which ruled against Asahi. Because remember that there were all these cross complaints. So eventually the only defendant left was Asahi, one of the foreign manufacturers. And then this was reversed by a court of appeal in California, which ruled for Asahi. And then the case reached the Supreme Court of California, which reversed and ruled against Asahi. And then you have, this process before the United States Supreme Court, which basically was ruled in favor for Asahi and found no territorial jurisdiction in this case. Okay. Anything you want to add, Tambi, to that?
No, I'm good. Thank you.
Well, thank you. You're doing excellent work here. Thank you so much. So does anyone want to tell me what the legal questions in this case were, the legal issues? And this is the kind of questioning that you're going to be receiving from your professors in your classes. So it's a good idea to start practicing.
I would like to talk about.
Judge Barr, do you want to try that?
I would like to talk about the legal issue because I had just a kind of fast reading before this Zoom meeting. And what I understood, the legal issue is whether the court would be able to apply its jurisdiction on someone who is not physically existing on the forum state or no. Because here I see that Asahi was actually accused of selling some not well good products in the California county, and at the same time whether the court wanted to decide whether he was willing actually to have a kind of commercial connection to the state or no, and it will be able to apply its jurisdiction according to what is called the term of what is called I don't remember right now, but due process or something like that.
Yes, and you know what, Judge Barr?
The due process clause.
Yes,
the due process clause.
There's a number of components of this case that are very interesting. I mean, the reason why we're having this case before the United States Supreme Court is because Asahi is a foreign manufacturer. Asahi is not based in California, and the facts occurred in California. So basically, you have a plaintiff trying to exercise jurisdiction, right, over Asahi, which is a foreign company, for activities and actions or product liability issues that happen in the state of California, right? So what is the extent of jurisdiction over a foreign defendant in this particular case? This is why we have a personal jurisdiction case here. This is something that was very well explained by Judge Barr. And I think one of the most interesting issues also in this case is that you have a constitutional issue, and a lot of students ask, why is a product liability action, how does a product liability action turn into a constitutional issue? Because usually those constitutional issues are seen by federal courts. They're seen by federal courts, they can be seen by the United States Supreme Court. So how does it become a constitutional issue? So that's actually one of the legal questions in the case, So I actually included some of the legal questions here for you, so that you have a snapshot of the kind of legal issues or questions that you can extract from a particular case. One of them is sole placement of a product in the stream of commerce, which means the fact that a foreign manufacturer, places a product, or basically sells a product or knows that a product is in the stream of commerce or is basically circulating, in some commercial way, in another country like the United States or in a state in the United States. So does that mean, that they had enough notice, or that they really had this intent to really reach the foreign state enough to have minimum contacts, And the minimum contacts test is a major legal issue in this case. At the end of the day, a lot of the discussion is whether Asahi really had minimum contacts with California, which means that jurisdiction could be exercised over Asahi. So that's one question. And Judge Barr was discussing that in his explanation. Another question is whether sole knowledge by a foreign manufacturer that its product will be sold and delivered in a state sufficient to satisfy that minimum contact test. And a lot of the legal analysis is the factors, how do you determine that minimum contacts or that a foreign manufacturer really had minimum contacts with that specific test. The other question is the scope of that test, right? How far can you go with that test to determine that there is territorial jurisdiction when defendants are foreign nationals? And lastly, as Judge Barr indicated, one big question in this case is, would exercising jurisdiction over Asahi, which is a foreign defendant, be consistent with the due process clause of the 14th Amendment, which is a constitutional issue as well? Okay, so there's a number of legal issues and questions in this case, and it is a good idea to include those when you do your case briefs. Again, you can do your case briefs in a more summary fashion, so that you don't feel like you have to include so much information. But it really depends on your style. Some students really would like to have case briefs that are much more substantial. Some of them would like case briefs that are a little bit more shorter than that. But the important thing is that you do aim at what's important in a specific case. Any of you want to try the holding of the case? What was the holding of this case? And the holding is basically the legal decision of the court. What did the U.S. Supreme Court decide in this particular case? Because this case actually reached the United States Supreme Court level, which is the highest level in the U.S. legal system. And that's something that will be discussed extensively in fundamental issues in U.S. law. Any of you want to try the holding of the case? Remember, it's good to start getting used to practicing and participating, because you're going to have to do it in your classes. Sharon. Thank you, Sharon. You're brave. Sharon. Can you hear me?
Can you hear me now? Sorry.
Yes, I can hear you. Yes.
Yeah. The Supreme Court of California held that because the Commerce eventually bought some valves sold by Asahi to Chengxin into California. So Asahi has aware that its valves would be sold in California was sufficient to permit California to exercise jurisdiction over Asahi consistent with the requirements of the due process of clause. So it has the minimal contact required to build jurisdiction in California.
The U.S. Supreme Court ruled in favor of Asahi, so it didn't find that it had enough minimum contacts to have basically an exercise of jurisdiction happen in this particular case. At the lower courts were divided on this, but the U.S. Supreme Court actually ruled in favor of Asahi, basically held that exercising jurisdiction over Asahi would be inconsistent with the due process clause of the 14th Amendment. And it indicated also that the minimum contacts test in this particular case wouldn't be satisfied, and basically reversed the judgment of the California Supreme Court. This is something that the U.S. Supreme Court can do, especially in constitutional issues or federal question issues. And that's something that we will be discussing in fundamental issues in U.S. law. And in this particular case, this is something that the U.S. Supreme Court ended up doing as well. But again, the most important part of the case is how the court got there, how the U.S. Supreme Court got there, what we call the legal reasoning or the rationale of the case. Any of you want to try the rationale of the case? And I know this is very challenging, and I just wanted to tell you that I really, really salute what you're doing right now, because it's very, very difficult to speak in class, especially about legal issues that are new to you. So I really, really commend all of you, and you're doing great. You're doing great. And this is something that we're going to continue doing, especially in your fundamentals classes. So please don't be intimidated. The idea is to get you to start practicing. This is something that I know that you're going to have to do a lot. So I see a number of hands raised for the rationale. Xiaoyun Liu, you wanna try it?
Yes.
Thank you. So let's talk about the rationale. What's the rationale of this case?
So I believe that it's the awareness of the individual of the product which produced or manufactured would satisfy the minimum contact of the jurisdiction. And the connection would be produced by the defendant's action within the forum state. But in order for the state to decide whether it can exercise its jurisdiction, well, it depends on several factors, which includes the burden of the defendant, the interest of the forum state, the plaintiff's interest in obtaining the relief, and also the interstate's interest in finding a more efficient way to resolve the case. And I believe it's a rationale within the case.
Thank you so much. That was actually a wonderful explanation. And let's go through some of the details, right? But I think you did a very nice job summarizing a lot of what the rationale is in this case. So thank you so much, Xiaoyun. A few things about the rationale that are important. First, the due process clause of the 14th Amendment is important and is related to this case, according to the ruling of the United States Supreme Court. So when you are reviewing any sort of ruling of the United States Supreme Court, it's always good to think about what the federal question is, what the constitutional law question is, why is the case before the US Supreme Court, And part of the rationale, for the US Supreme Court is that the due process clause limits the power of state courts to exert personal jurisdiction over non-resident defendants, and that determination of whether there can be personal jurisdiction in a specific case really depends on minimum contacts with forum state. That means that Asahi needed to have those minimum contacts in order for California to be able to exercise jurisdiction over Asahi. And there's a number of factors that the court advances in terms of how do you satisfy that minimum contacts test. In this particular case, you need a substantial connection with the forum state. It's not just based on the unilateral actions of the consumer, and actions by the defendant need to be purposefully directed towards the forum state. This is very important terminology because this is all part of the rule of the case, and there's actually a lot of discussion by the court as to how this legal rule came to be, even the evolution of cases and jurisprudence, and why do we have this minimum contacts test right now, and why do we need that substantial connection and also this purposeful direction as well, okay? A few factors that are important for the court, and this is very important because this is all part of the rationale of the case, how the court got to that analysis. Basically, you need to find this intent to serve market in forum state. So there's a number of factors: designing product for the market, advertising, establishing channels for providing regular advice to customers, marketing product to distributor. Sole placement of product and stream of commerce is not enough. I mean, it's a high standard, and that's important to keep in mind when you're reviewing this case, which you will have an opportunity to review again in fundamental issues in US law. And basically that defendant's awareness that stream of commerce may sweep product in forum state is not enough. There has to be more, So when you are analyzing a case and you are working on that case brief, one of the most important components of that case brief when you're actually describing that rationale is identify factors and tests. This kind of legal analysis is very important because this is what you will apply to another case in the future. I will give you an example. In the US Supreme Court decision that you had to read, there's not only a description of this rationale and legal reasoning, but there's an application of that legal reasoning and rationale to the facts of the case, to what happened to Serker and his wife in the motorcycle accident. Okay, and there's actually a very detailed analysis of how basically Asahi, the court considers that Asahi didn't purposely establish minimum contacts with California to avail itself of the privilege of conducting business activities in the state. And then it goes through the motions. Asahi has no office, property, or agents in California, made no direct sales in California, had no distribution network in California, does not advertise in California or solicit business in California, and Asahi merely put its product into commerce. No evidence of intent or purpose to serve California market. So when you are doing your case brief, it's a good idea to capture this because this is what happened in the Asahi case, right? And this is the, this is part of the rationale that you would apply to different cases. But it's also good to start thinking about alternative fact patterns, What would have happened if Asahi would have had an office in California, Or imagine if Asahi was Apple, a company like Apple, that it has, web presence all over the world. Do you need offices in a specific state, to show that intent, to really serve or benefit from that market, Think about what would really satisfy minimum contacts, Think about different fact patterns than this one, And that's a lot of what you're going to be doing in our final exams. So it's a good idea to start thinking about how this would work, with a different fact pattern as well. In terms of the rules in this case, anybody want to try to describe the rule in this case? What's the legal principle that would apply to future cases? Anybody want to try that? And remember, this is a comfortable zone. You do not have to be perfect. You're all doing great so far. Any of you want to try to tell me what the legal rules in this case are, or the legal principles?
Can I go ahead?
Yes, sorry for the thank you, Davron.
Yeah, I am on a new device, so that's why I couldn't unmute myself last time.
And Davron, Davron, I wanted to tell you, no worries. This is the first, in many ways, this is kind of like the first class that you're having. So, and it's online as well. So it's completely okay, to not do everything perfectly. So please, no worries. And thank you so much. You want to tell us what the legal issues are? You want to try it?
Well, I would like to concentrate on one of them, that there are a lot of them, but I would like to concentrate on forcibility. The case established something that that company who's producing that certain type of items cannot be responsible, cannot foresee that which place they will be sold in the future. So this was a main rule which will be applicable for other relevant rules, other relevant cases. So that's why the important thing is forcibility, and they were referring to a worldwide Volkswagen case, I guess. Yes, and they were referring that no company is responsible that if the driver will be in some way in the world use the product. So this was the main rule will be applicable in future cases, I believe.
That's excellent. I mean, foreseeability is a huge factor here. The U.S. Supreme Court in many ways sides with Asahi because it considers that it wouldn't have been foreseeable for them to be subject to litigation in California by just placing, their product in the stream of commerce, because they found that they didn't have that intent to serve the market. So foreseeability is definitely a big component of the legal rule. I like also, Davron, a lot that you mentioned the precedent, other cases that the Asahi court, the US Supreme Court referred to reach its determination. I mean, when you look at, the Supreme Court decision of Asahi, there's a number of cases that are actually mentioned, and one of them is the Volkswagen case. There's also the International Shoe Company case. I mean, there's a number of cases that are used there as precedent that the U.S. Supreme Court is either applying or interpreting or following or not following. That happens as well. The U.S. Supreme Court sometimes doesn't follow precedent, but it does have to justify that break in precedent, right? Because this is a system where you really have to follow that precedent. Otherwise, if you're going to change precedent, you do have to justify it, So I think that was excellent. Thank you so much, Davron. So let's go through some of the rules of this case. We have a rule, of course, connected to the due process clause of the 14th Amendment, and basically the rule is that personal jurisdiction depends on minimum contacts with that forum state, and actions by defendant need to be purposely directed towards forum state based on the factors listed in the ruling. And you can include the factors, in your case brief as well. There's also notions of fair play and substantial justice, when it comes to the 14th Amendment application in this particular case. And there's not only the question of foreseeability, but also reasonableness in the exercise of jurisdiction in this specific case and also in future cases, and it really depends on an evaluation of a confluence of factors, potential burden on the defendant, interests of the forum state, what kind of law you want to apply in that particular, case, for example, state or federal law, the plaintiff's interest in obtaining relief, the efficient resolution of the case, or state's interest in furthering social policies, Another thing about outlines, before we go into outlines, which are also a major component of the studying techniques that you're going to have, make sure that you don't make your case briefs too complicated. I always tell students, make sure that it's something that you can use, and use your style. I'm giving you one style of how to prepare a case brief and how to prepare an outline, but I don't want you to be intimidated. I don't want you to look at this PowerPoint and be like, oh, how am I going to do this for every case in every class? You have to find a formula that works for you. The most important thing is that you're well prepared for class, that you can actually answer questions like the ones that I posed. I posed some questions about the case, and most of your professors will be asking you specific questions about the cases, especially, what is the rule? What is the rationale? What is the holding? What are the facts? What are the procedure history? I mean, these are all very common questions. So it's a good idea to have those case briefs at hand. And I wanted also to open the opportunity to ask me any questions you have on case briefs. And remember that you can ask any question that you have. This is a comfortable zone. It's a safe environment. I always tell students, I love working with graduate students, and I don't bite. So it's okay to ask any questions you have. So any questions, you have any questions right now, anything, and nothing is too basic. Remember, you just started a graduate program at a major law school. It's completely normal for you to have questions. Any questions that you have? I don't see anything in the
I have a question.
Okay, Temis. I see Temis. Hi, Temis.
Hi. I have a question with the rational component. I just had the question, is it only, I know it's like the summary or like the analysis that Supreme Court makes, but it doesn't have to be legal rationale. It also has facts.
That's a great question, Temis. Yes, I mean, some of the analysis is very legal, right? A lot of legalese, a lot of application of, or basically, this analysis or journey to get to the rule, right? That's going to be applied, etc. But sometimes, like you say, there can be other considerations, and this will become much more clear to all of you when you start reviewing cases, for example, related to the political question doctrine. A lot of those questions, they have policy considerations, of whether, the U.S. Supreme Court wants to intervene or doesn't want to intervene. There's legal analysis, but you can tell that there's also political and social and economic considerations, even though, the courts are supposed to stay away from those. Sometimes they do include, I would call them policy considerations. Like, for example, I'll give you a very typical policy consideration. A lot of our federal courts stay away from state court issues, because of the state comity or respect to the states, deference to the states and state law matters, right? So they try not to get involved with state law issues unless they really have, an implication for more than one state, or they have a federal question, or they have a constitutional question, right? But you will see the word comity used a lot, state comity, deference to state, respect to states. Respect to federalism, that the federal government handles a number of matters and states handle other matters, and that's something that we will discuss a lot in fundamental issues in US law. So a lot of what I'm explaining to you, if these are concepts that you've never heard of, don't worry, because we're gonna discuss them in a lot of detail starting next week. But Temis, I think you make an excellent point. I think, for example, something like fair play and substantial justice, for me, it's a legal principle, but it's also, if you think about it, it's also a policy principle, right? You know, it's
Yes, it can be also put as a rational component. Yeah.
Exactly. There's also something that you will see in cases that what we call dicta, you know, that the court will include all these considerations, but they're not necessarily the legal rule, but they're considerations that impacted the definition of that legal rule, you know, so you'll see that as well. But I always tell students, the key, focus on the basics. Make sure you have those basics down on the case, right? And then afterwards, you focus on the frosting, the flowering of the case, you know? But just make sure you have those basics first, you know, because it's very easy to kind of get lost in these cases. And you'll see some of the cases that we will be discussing in fundamental issues in US law, you're gonna be like, wow, but there's like 10 different kinds of rationale in this case, right? So it's a good idea to kind of look at the basic, what's the basic rationale, what's the basic rule, right? And after you master that, then you focus on the frosting, as I say. You focus on the flowers, you know, you focus on that beautiful language, you know, and you'll see that there's a lot of that in the, especially in the United States Supreme Court decisions. You know, sometimes judges can be very poetic, you know, especially for the groundbreaking decisions, you know, like, so it's good to think about the, you know, what's part of the basic facts, what is the basic history, you know, what's my basic rationale? How did the court, you know, what was the analysis in this case? What's the holding? What's the legal rule? And then afterwards, you focus on all these other details. That's why these different reads can be very useful, especially at the beginning, because some of the cases are very difficult to read. I mean, you have to read for next week, you have to read Marbury versus Madison, which is one of the most important cases ever decided by the United States Supreme Court. And it's a very difficult case to read, you know, and it's a case that we're still interpreting what its connotations are until today, right? But you'll see when you read it, you're like, there's so much language in here, you know? The political question doctrine cases as well have a lot of language. The territorial jurisdiction cases like Asahi are a little bit more put together, in my view. That's why it's good to use the Asahi case for this kind of workshop, because it's easier, it's a little bit easier to understand the rationale and the test, et cetera. But other cases are definitely much more complex. So you will see an array. So it's good. I think the thinking that you're doing, Thomas, is very good. And the important thing is, since we are at a law school and you are going to be in legal courses, make sure that you understand the law first, and then you focus on the other, you know? So make sure I make sure that you get those basics, you know? I also have a question from Destiny.
Hi.
Hi.
So my question is really with regards to the indemnification claim. I was a little bit confused about like why that claim was there and like how relevant it is to, if it's relevant to the case briefing components, or is it something that we could easily ignore as we build up our case briefing components?
I think that's a great question, Destiny. I think the indemnification claim is important in this case, but I wouldn't highlight it as the most important component. I mean, at the end of the day, the reason why we have a case before the U.S. Supreme Court is a personal jurisdiction matter, okay. Right? You know, so I would focus more on that. It doesn't mean that you're not familiar with the facts of the case, you know, but at the end of the day, when you look especially at that United States Supreme Court decision, and the legal analysis of the court, this is really a due process law case, you know, under the 14th Amendment, and it's a personal jurisdiction matter. And it's a case about the minimum context, you know, the minimum context that a foreign defendant needs to have with a specific state, you know, for their state courts to be able to have jurisdiction over this defendant, you know. That's really the basic gist of this case, and in one layer. But one thing that you'll notice with these cases is that they have 5 layers, right?
Yeah.
So I always tell students, focus on divided by layer. You know, what's the main layer of the case, you know? And then what's the second layer? What's the third layer? What's the fourth layer? What's the fifth layer? And remember, it's very important to understand what that top layer is, because that's probably what you're going to need to apply to a future fact pattern, right? You know, you will probably get a fact pattern in an exam, and that happens in fundamental issues in US law as well, that suddenly, you know, you have you know, a car accident, right?
Mhm.
And suddenly there's like all these manufacturers involved, you know, in the piece of the car, you know, that provoked the accident, right?
Yeah.
And 3 of them are foreign and 2 of them are from the US, right? Are based in the US, you know? And suddenly you have a personal jurisdiction issue, right?
Yeah.
You know, the important thing is that you recognize the issue, you know? When you have that hypothetical question, you know, when you write that exam, you say, oh yes, this is a personal jurisdiction issue because we have all these foreign defendants, you know, and basically the allegation, you know, is that there was a failure related to the way this car was manufactured or working, et cetera. You know what I mean? So that's the kind of thing that you're going to have to do in your final exams. Basically, it's applying these rules to a new patent, right? So it's good to start thinking when you read those cases, how would this, you know, how would the situation been different if Asahi had an office in California? You know what I mean?
Mm-hmm.
And I think also where these fact patterns get really interesting is when you start thinking of the virtual world. Remember that we're in the digital world extensively now, right? So if you're a major company, do you need to have an office in a specific state to, you know, for a plaintiff to prove that you intended to serve that market, or whether web presence is enough, for example? And that's a big question now because, you know, right now we live in a virtual world. You know, how do you determine minimum contacts now? You know, do you need to pay taxes in that state?
Yeah.
You understand what I mean? So it's good to start thinking how those factors would apply to another case.
Okay.
So it's not to say that the indemnification claim is not important. It's just that you have a case before the US Supreme Court. So why is the case before the US Supreme Court?
Okay.
And that's important to keep in mind. Keep in mind those basics first, and then you focus on the layers, right?
Okay.
You know, and let me tell you, I mean, a lot of us love looking at those layers because we like the law, we like case law, right?
Yeah.
So it's great those layers too, you know, not just this basic gist, but especially when you're starting and to succeed in your classes, you know, it's very important to be able to capture that first layer in cases, you know?
Okay. Yeah.
And remember that you can also be more detailed in your outlines. You know, we'll talk about outlines after the break, and you can be a little bit more detailed in outlines as well. Case briefs are more to prepare you for class, to be able to answer questions that your professor poses.
Okay.
And I encourage you all to participate in class. I always tell students it's good to at least raise your hand at least once in class so that the professor knows who you are, because professors have a lot of discretion in the way they grade at the law school. And even though part of the grade is blind examination, and of course in blind examination, professors, you know, they will give you a grade without knowing who you are, but they can bump grades based on participation. So I always tell students, you know, it's great to have solid class participation, because imagine if you got a C+ in a test, you know, and the professor remembers you because you were an active class participant. So suddenly you get a B- instead. There's a big difference between a B- and a C+, right? So it's good to get you to, and it also trains you. I always tell students that, you know, it's great to train yourself to think on your feet, you know, because when you're, and many of you are attorneys already, you're lawyers already, so you know this, you know, when you practice law, you do need to be able to speak, you know, and speak well and advocate well. So I think one of the most wonderful things that a law school can give you is the opportunity to do that. And in a classroom, which is a safe space, you know?
Yeah.
You're not in front of an actual judge. You're not representing a client. And that has more stakes, right? That's much more, you know, that the stakes are higher, you know? So keep that in mind, you know? Any other questions before?
Thank you.
Of course. Oh, I have more questions here. This is wonderful. Good. I have Shoujun.
Yeah, so I have 2 questions. So the first is that about the issue part.
Yes.
Every time we read the case, is it necessary for us to conclude all the issues that are raised by the court, or we only have to focus on the core or on the main issues? A little bit.
That's a great question too, Shoujun. I would identify first the core.
Okay.
Core issue. and then I would add the rest, you know, but I would make sure that you identify the core, because what happens with a lot of students is that they're great at absorbing everything, but, you know, sometimes they miss the core, right?
Mhm. Yeah.
And you want to make sure you don't miss that core. So for example, in this case, the minimum contacts test is a huge component, right? The fact that the due process clause of the 14th Amendment is involved is a major component because it's a case before the United States Supreme Court, right?
Yeah.
So make sure that you identify those core components and then you can add the rest, right? Just make sure you don't lose, you know, the most important part of the case, you know? It doesn't mean that the other parts are not important. It's just make sure you focus on the basics, you know?
Okay, got it. And I have a second question is,
Sure.
I'm a little bit confused about the rule part and the reasoning part, the rationale. Is that the rules are like the jurisprudence or the articles behind this case, and the rationale is like to combine these principles or the articles into this case to explain how the court to have these decisions.
That's an excellent question. The reality is that rules are not always articles or sources of law. Rules can be legal principles, because for us, case law is a source of law, right? So at the end of the day, you won't always have a rule that's based on a statute, for example, you know, or a specific legislation or law or article of the Constitution, or like not necessarily. Sometimes you have decisions, you know, that are based, you know, on common law, you know, on case law, right? The big difference between rules and rationale is the journey, you know, it's the journey, the process, the methodology that the court used, you know, to reach its final determination, you know? The holding is the final determination. And then the rule is the legal principle that comes out of that rationale.
Okay.
Yeah.
I have a question.
It's you know, and this is something that as you read cases, as we move along through fundamentals, it will become more clear, I promise. When you first read cases, it will still be a little bit confusing. So what I want you to do is to start practicing extracting that rationale and those rules and that holding, you know, and you'll see that it's going to become, as you go to class and participate in class, and as cases are discussed, it starts becoming a little bit more clear. Another thing I wanted to say is that the first day of your legal research and writing 1 classes, you know, the ones that you're required to take, you will also go through case briefing and outlining. And I think that will also help you review a lot of these issues and materials and practice, you know, practice also. You're going to have to do a case brief, you know, of a case and then Excel book. And I think it's good for you to practice to do these case briefs. And what I want you to do also is to practice doing these case briefs next week. For those of you that are going to be taking fundamental issues in US law with me, you can practice. And I really believe in comfortable classroom environments. So if you have any sort of questions, you know, that you did your case brief and it's this beautiful case brief, and you're kind of confused as to whether you identified the rationale well or the rule well, we were going to have the opportunity to discuss this next week as well. So it's okay to practice. It doesn't have to be perfect. I just want to make sure that you start practicing this, you know, so it becomes more familiar to you. And you'll see in 2 months, you're going to be reading cases like, you know, it's going to be much easier than now. Now it's the beginning. And at the beginning, it's a little bit dry. It's a little bit dry when you read those cases. And especially the first cases that you have to read, you know, they're very lengthy, and many of them are cumbersome, and many of them are very flowery, and the language is not necessarily that clear, you know? So I have more hands raised, so I want to make sure you have opportunities to ask questions. So I have Temis.
Dean?
Yes.
I'm so sorry, I don't know the hand raised button. I couldn't find it. Okay.
That's okay. That's okay. We also have Tambi. Tambi.
I think Isam would like to go first.
Is it okay with you, Tanvi?
Absolutely, absolutely.
Okay. Thank you. Dean, I was just wondering, because at the beginning of the case, it was more about the product liability action, and somewhere in between, the dispute was more about the indemnification between the two companies. I was wondering where, somewhere in between the case, the safety aspect was not covered, because I felt that the whole case was about the safety. Initially, when the case was filed, it was to do with the safety, but at the end, the safety aspect was not covered anywhere. So I don't know. I'm a little confused about that.
Well, it's a wonderful question. I mean, what happens in a lot of these cases is that we have a lot of different motions, that plaintiffs and defendants can present. And in this particular case, by the time it got to the Supreme Court, most of the claims had been dismissed, which means that, the case in many ways wasn't really about product liability in some ways. It was really more about Shengxing, one of the manufacturers that had filed this cross claim against Asahi. So it really became more about that dynamic between the manufacturers and the foreign defendants as opposed to the product liability action, because of all those motions in between, So when you see, and usually what happens with these motions is that the particular parties can request the court to either, decide in a summary judgment way or dismiss it, because of lack of substantiation. There's a lot of different kinds of pleadings that you can include in motions. And in many of these cases, what happens is the case ends up being about something completely different, by the time it reaches the Supreme Court, of the state. And if it reaches the United States Supreme Court, usually there's some sort of federal question involved, or a constitutional question involved, or an issue that states have differences on, that you have different Supreme Courts, from states that have different interpretations, and the Supreme Court believes that this is an important matter to review. Remember that our United States Supreme Court only reviews cases on the basis of certiorari, which means that most cases are not seen by the United States Supreme Court. They can exercise their discretion on some cases. So usually when they see something that was ruled already by a Supreme Court of a state, usually they have to see some sort of federal question or constitutional issue involved. So in this particular case, you did have a lot of motions, and basically what happened is a lot of those motions basically ended up dismissing many of the claims, That's why the case at the end, it's really more about the manufacturers, the foreign manufacturers, at the end of the day, But that's a great question.
Thank
so
you.
I have Tambi.
Yes, hi.
Hi.
I wanted to know also how important is also the cases referred by the court in any particular judgment?
That's a wonderful question. They're a basic, you know what I mean? There's the basic precedent that the court is applying. So this is part of the legal rationale, right? It doesn't mean that you have to know that those cases by memory, but it's good for you to understand the origins of the legal rationale of the court, It's the origins, where it comes from, and what the court is applying to determine what the rule is in this particular, or how it is applying that rationale to the facts. So it's good to know your foundational cases, right? And how they have been applied in a specific case, but it doesn't mean you have to know them every detail and every fact. It's just that they're the case that have the originating rule, the original rule that the court is applying in that legal rationale. It's good to be aware of the cases, of what they are, It's like, I'll just give you an example, the US Supreme Court just ruled the case, the Nestle case, which is, it's a very interesting case. It's related, to the line of cases of the Alien Tort Statute. If you are doing any sort of studying on the Alien Tort Statute, it's very important to understand what SOSA is, what Kyobo is, like all these other cases, Jessner, that have been ruled by the US Supreme Court related to the Alien Tort Statute. So understand the history, to understand the history of rulings, and without losing sight of what's happening in that specific case that you have in front of you, right? Because that's the one that you're going to be expected to apply in an exam, in a final exam, right? So it's more where the rule originates, because in the US legal system, case law is a source of law, it's a source of common law. So it's good to understand where the original rule came from, it's background, important background.
Thank you.
Of course. Berta.
Hi.
Hi.
Hi, I've got a question. How do you get like a general rule if the rationale is not well supported or it's not very clear? I'm saying this because I get the sense that there's not like a clear link between the 14th Amendment and a fair trial or a due process.
That's debatable, Bert, you know? And at the end of the day, that's your personal opinion. So what I always tell, new students is like, it's very important first to understand the legal rationale, to understand the rule, to understand the basics of that specific case, what the law is, and then afterwards you can develop opinions of whether you're in agreement or not with the rule or the law, right? There's a lot of cases, like you say, that maybe they're not that well supported, but that's a matter of personal opinion, because at the end of the day, in the US legal system, when you have a case adopted by the US Supreme Court, we can agree or disagree, but it's the law of the land, right? So it's very important to first understand what the case is about, and then you can have opinions on it. I can tell you the amount of cases adopted by the US Supreme Court that I don't agree with. So I feel like you in many cases, that I just don't agree with them. I'm like, why was this decided this way? I don't see any sort of justification here. I don't agree with this, you know what I mean? And I can give you 5 different reasons, why, but it's the law. Unless the case is later overturned by the US Supreme Court, it's still the law of the land, right? So for your classes, my recommendation is first focus on what the law is, what the case is saying, what the rationale is, what the rule is, right? And then you can develop your opinions on it. But make sure that your opinions don't cloud what the law is, right? Because our task as law professors is to show you what the law is, not necessarily to always discuss what the law should be, right? So make sure that you keep that difference. And I hear you, because I'm a human rights attorney. I am an international law specialist, so you can imagine, the opinions that I sometimes have on cases, but I've also understood that part of being a US lawyer, and a US well-trained lawyer is understanding what the law is, right? Whether we agree with it or not. And there's always different sides. And that's also very important to keep in mind. Every Supreme Court decision, remember, the Supreme Court is a very powerful court in the United States, every Supreme Court decision, it has its opponents and it has its supporters. Every one of them. That's why you have dissident opinions. Even the justices, discuss these opinions. This is why you have the dissident, you have dissident opinions by even the justices, because sometimes they don't agree on the legal analysis, but just make sure that your actual personal opinion doesn't cloud what the law is, because that was already settled by the United States Supreme Court. It could be overturned in the future, but in many cases that you will be discussing in your classes, it hasn't been overturned yet, right? So even if you don't agree with it, it's a good idea to always focus on that law. But I hear you. I hear what you're saying.
Thank you.
Of course. Ms. Tang?
Dean, I was wondering, in order to exercise that jurisdiction under the due process clause, is awareness or the minimum contact always the determining factor?
Well, according to the Supreme Court, you do have to look at those factors. And the test of the minimum context test has evolved. You have the Asahi case, you also have the Jay McIntyre case, which you will also be discussing in fundamental issues in US law. So the test has evolved over time. So you do see different factors, different terminology. And remember that you can always make an alternative argument in your exam. Just make sure that you apply the current law and explain why you would apply it differently to these set of facts. What your professors want to see is legal analysis. They want to see good legal argumentation in your exams, So, and good legal argumentation can go both ways, right? It can be in favor of Asahi or, in favor of, slightly changing the rule, etc. But what your professors really want to see is that you do know what the law is, right? That you're not applying different law just because you're in disagreement with it. you know? So, but the factors, what the Supreme Court has done is that it has ruled a number of cases that have different iterations of those factors, you know, including the Jay McIntyre case that we will be reviewing in class as well. But remember, focus on the core. There is a minimum context test and there are factors, right? And the factors can be different case by case, right? But it's very important to remember that there's that test, you know, because that's the basic principle. Yeah.
Thank you.
And I'm looking at the chat to see if we have any other questions. No, I think we're okay. Yes, I will send the PowerPoint presentation after this, so you will be able to review this again, and you will have also an example, you know, of how to do case briefs and outlines, etc. I will definitely share this PowerPoint with you as well, and the recording will also be available. You know, if you would like to see the recording after the workshop, see it again, kind of review, etc. This is part of your orientation, so definitely that will be available. It's 10:10, so I'm going to give you a 5-minute break so you can go stretch and rest a little bit, and then we will go back to outlines. We will talk a little bit about how to outline, and we will talk about those research papers, and also we will talk about plagiarism, which is a major issue. I will give you a 5-minute break, okay? And thank you all for your participation. This is great.
Oh, I've actually done this.
Testing, testing.
Okay, let's resume because I want to make sure, that we have enough time to cover everything that we want to cover. And I hope that you were able to have a bit of a break. And I wanted to actually devote the second section of this workshop to one very important studying technique, outlining. And as I indicated at the beginning of this workshop, outlining has been a technique used by law students for years to succeed in their law school classes. Some of the best students that we've ever seen at this law school have actually outlined. So this is why something that we always recommend students to do. And a lot of students ask me, they're like, oh, what if I find an outline that was already made? Can I use that? And I'm like, well, the problem with those pre-made outlines that you can find on the internet, for example, is that you're not going through the process. You're not going through the process or the methodology to be able to really extract, that rationale and that rule and that holding, which is very important, to become a skilled U.S. lawyer. So I always tell students that part of the outline is really to train yourself, to really not only absorb these cases, but to be able to apply them to future fact patterns. I always tell students it's a good idea to try to do the outline yourself, even though this can be very time consuming, and it's a way for you also to study, Another thing that's very important about law school to keep in mind is that this is not the kind of system, especially the US legal system, where memorization works. This is not the kind of system that just memorizing the cases and the rationale and the holding, on the rules is really going to help you succeed. At the end of the day, it's more of an application system. You're going to have to apply, the principles that you learn in class and the cases to new facts, and to fact patterns, So at the end of the day, the outlining helps you prepare for that kind of exercise during your final exams as well. So I always tell students that it's a good idea to go through the methodology and the process of preparing an outline, even though it can be very painful. It is a good idea to do your work as you go, to not leave all of your work for the last minute. I wanted to give you some examples of and tips of how to create outlines. And again, outlines, you can use your own style when crafting outlines. You don't necessarily have to use the style that I'm conveying to you. And also your legal research and writing professors will give you also different styles of outlining. And the idea is that you pick a style that works for you. In terms of what the outline is, in terms of the content, you really organize and concepts and sub-concepts that you have been discussing in class, and you're building an outline around these. It is a good idea to use your syllabus, in a class to build an outline, and I'm using as an example, your typical fundamental syllabus. For example, you can have concepts in a syllabus per class. For example, a topic can be judicial review or political question doctrine or personal jurisdiction, depending on the class. And then you'll have sub-concepts under those concepts. Like for example, under personal jurisdiction, you usually have subject matter, you usually have territorial, you usually have diversity jurisdiction. So it's good to think about those concepts. Remember those rule statements, those rules, and remember that the rule is the legal principle of a case. Remember that the rationale is the journey, the journey to get to that holding, which is the final determination of the case. And the rule is the actual principle that you will derive from a specific case. And remember that your cases are examples of how that rule has been applied in the past, okay? So that's why those cases that you discuss in class are very important, because they give you an idea of how you would apply that rule to future cases. Remember to get those basics first. I always tell students, get basics first, get the core first, and then you include the dicta and the nuances and the policy considerations, etc. Make sure that you don't get lost in the details. Make sure that you always have those basics down first. The other thing about outlining, the outline should be helpful for your final exams. We do offer practice exams. Like for example, in fundamental issues in US law, I have one practice exam, a midterm practice exam, and we also do a practice exam in legal research and writing one at the end of the semester. It is a good idea to test your outline in those practice exams. And I always tell students, use the same outline that you have been using, the one with yellow, the one, that has the cracked pages, the one that has coffee spilled on it. Don't change outline. Because at the end of the day, you want to use the one that you're comfortable with, the one that you have been using, because usually when you're doing exams, even though, for example, the fundamentals exam, home exam, it can be nerve-wracking to be working on an exam, so it is a good idea to use your same outline, okay? So a few things. remember that this is all based on the Asahi case, right? And remember that this is a matter related to personal and territorial. I'm giving you some components of what And I think that there was a question earlier, which I thought was great, about, where do these rules originate? Like when the US Supreme Court does its analysis in Asahi, what are the cases that it is using as precedent to actually get to Asahi? So I include a little bit of that, at least some of the basic rules and the principles in this outline. So when you're thinking, this is a first section, remember that concept, the big concept is personal jurisdiction in this particular case, and the sub-concept in many ways is territoriality, or territorial jurisdiction. So in this particular case, I think it's very important to understand that there's a basic rule, and then there's a number of rules connected to that basic rule. So the basic rule is that courts have power to adjudicate matters concerning persons present within their physical territory when a suit is commenced, right? Mere physical presence in the forum state where suit is filed is no longer required, right? This is the basic principle in many ways. And this is why we have this case, right? Because it's a foreign defendant. So the fact that they're not physically present doesn't mean that jurisdiction cannot be exercised over them, right? And then I incorporate the constitutional issue here, the 14th Amendment and the Due Process Clause, and this is based on the Asahi ruling. The Due Process Clause protects foreign litigants from litigating in distant forum. And also in a way, it is applied by the court in Asahi as a protection, as a layer of protection against, or to protect manufacturers that are foreign, that don't have physical presence in the forum state. And it also assures that states do not reach beyond limits as co-equal sovereigns in a federal system. That's a policy statement that the court makes in the Asahi case, right? This is part of the dicta you know, that at the end of the day, you'll see this a lot when the US Supreme Court rules. You know, they have the federal courts have a very interesting dynamic with the state courts in the United States. So a lot of the decisions that they make is like they're trying to put some limits on what state discretion is or state jurisdiction is in particular cases. And this is something that you see in the Asahi case, okay? And then remember, we have that famous minimum context rule, right? And one very important aspect of the Asahi case is that basically the US Supreme Court says this rule has constitutional implications. You know, it is connected to the 14th Amendment of the US Constitution. When you are reviewing any sort of US Supreme Court case or federal court case, and we are going to discuss next week the federal court system and the state court system. In the federal courts, it's always a good idea to look at whether the court has been looking at a constitutional issue, because that's a supreme law of the land, you know? So at the end of the day, that's usually a major issue in federal cases. And in this particular case, there is a connection between that rule to this major constitutional issue. This is why we have a case before the United States Supreme Court, you know? And remember the principles under that minimum context rule. A person can be present in a state if sufficient minimum contacts are present that the suit does not offend traditional notions of fair play and substantial justice, right? And this is International Shoe Company versus Washington. This is one of the originating cases that is relied upon by the US Supreme Court when it makes its ruling. And remember that purposeful availment. This is very important, a very important standard advanced by the Supreme Court, and also the reasonableness standard. And I would also add what Dabron indicated, the foreseeability standard. Even though the court doesn't necessarily say foreseeability standard, there is kind of a foreseeability standard advanced by the court in Asahi. So I would add that there too, okay? And then you put a case example of all these principles. And your case example is Asahi. It's the case that you had discussed in class. You summarize the facts, you summarize the holding. That gives you an example, you know, the slide of what a holding can it look like. Exercising jurisdiction over Asahi would be inconsistent with the due process clause of the 14th Amendment, or that's the final decision of the case. Minimum context test is not satisfied in this case. No evidence of intent or purpose to serve the California market. And remember the application of that rule to the facts. That's very important because that's what you're going to do in future testing. Asahi had no office, no property, no agents, no direct sales, no advertisement or distribution network in California, had merely placed product in stream of commerce. And remember, you're thinking, if they give me a fact pattern, if my professor wants to play with me, gives me a fact pattern in which the name of the company is another name, and it just so happens that the company has an office or property or agents or direct sales or advertisement or a distribution network, you know, in the state of Florida, another state, you know, how would I apply this rule to that particular fact pattern, right? This is why it's very important to identify that rule, because that's what you're going to be applying in the future, okay? After you have those basics, I just covered the basics of the case. Then you go into the rule nuances, which are the details around the rule. But make sure that you don't miss the rule. We have a minimum context test, right? And that's the standard, you know, for personal jurisdiction, to avoid that this becomes a constitutional issue, right? So at the end of the day, we have details around that rule. And that you can include in your outline as well. You know, that's where you can include, remember, the purposely directed in terms of the activities, you know, the factors, right? What are the examples of intent to serve market and forum state? Designing product for the market, advertising, establishing channels for providing regular advice to customers, marketing product to distributor. And remember the policy issue, you know, the fair play and substantial justice and the reasonableness standard or the foreseeability standard in this particular case, you know, and the factors that the court uses to determine whether it was reasonable to exercise jurisdiction in this particular case or not. You know, the burden on the defendant, the interest of the forum state, plaintiff's interest in obtaining relief, efficient resolution, or the state's interest in furthering social policy. right? But again, these are nuances. Remember the layers? This is like the third layer of the case. I remember to focus on that first layer. Make sure you don't miss the whole minimum context issue and the fact that this can become a constitutional issue because it's a full process issue, especially if you're trying to exercise jurisdiction over foreign defendants, and it could, implicate basically exceeding states from their personal jurisdiction limits, So any questions on this? And I know this is a lot of information, but remember, this is just an example. This is to get you to start thinking about this and think about the kind of outlining you want to do. Think about the way you want to present this and would be useful for you to have for an exam. I just want you to start thinking about it. And it's a good idea to outline a little bit each week. I always tell students, like, don't leave it for the last minute, because usually when you outline at the last minute, it's very difficult because you haven't gone through that process, so at the end of the day, I'm not sure if that's really going to help you for your exams. And I always tell students, try to prevent buying outlines or pulling them from the internet, etc., because you're paying for such an expensive education. I always tell students, GW is so expensive, I would think you would want to get something out of it, and this is part of the education and the learning that your professors are trying to give you, So I see a number of hands raised. I have Temis. Temis, do you have a question?
No, I didn't raise my hand.
Okay, I see your hand raised. That's why I asked.
I'm sorry.
That's okay. Kazan, do you have a question?
I don't for now, so sorry.
Okay. And I see Andrew's hand raised as well. Andrew, do you have a question?
Can I start?
Yeah, she was talking about federal rights. Can she give an example of where states' rights would be supreme and the federal government would have no authority over that state right?
That's a great question. I mean, the reality is that this is a federalist system of government. And that's something that we're going to be discussing next week. That means that there are areas where state law is supposed to govern, and there are areas where federal law is supposed to govern. Usually, state law governs when it's a matter that's only related to one state, right? Usually, when you have a federal question issue is when you have an issue, for example, that raises issues concerning the United States Constitution, or you have what we call a federal question, which means that more than one state are involved, and it's also related to monetary amounts as well in terms of the entrance of to federal courts. Like we always say that, you have something called diversity jurisdiction, which we will be discussing, and fundamental issues in U.S. law that, matters that go over a specific amount, for example, 75,000, that could actually help the argument that a matter should be seen in federal court. But there's definitely a wide array of issues that are resolved at the state level, and many matters in the United States, legal matters, are resolved at the state level. And also state courts, the processes tend to be simpler legally. Usually we say that if you turn something into a constitutional question or a federal question, it turns very complicated legally because you have to navigate the federal courts, and it's also more costly monetary wise. So in many cases, it is in the interest of plaintiffs to keep things at the state level, but in some matters, that's not possible. I'll give you an example, just an example. And this is an example that we're going to be discussing in fundamental issues in US law, the question of marriage equality in the United States. We had 50 states that had different kinds of legislation, and regulation related to whether same-sex couples could marry or not, right? And many of these cases were challenged at the Supreme Court level. So we had all these Supreme Courts, that had different interpretations, of what the right to marriage equality was using state law. This was actually appealed, or there was a request for certiorari by the Supreme Court derived from some of the Supreme Court decisions. So the case ended up being at the US Supreme Court level, so the US Supreme Court turned it into an equal protection clause issue, a constitutional issue, and it ended up basically clarifying the law on marriage equality, legalizing marriage equality at the level of the United States. So it's an issue that started being a state law issue, but it eventually became a constitutional issue and an issue where the Supreme Court really felt that they needed to clarify the law, right? So at the end of the day, it's not that plaintiffs prefer being in federal courts, you know. In some matters, they may prefer being in federal courts, you know, but in some matters, they do prefer to be in state courts. And many matters like family law issues, for example, most of them are seen at the state court level. It's only a very small handful of cases that are related to family law questions that become federal issues, right? So at the end of the day, you do see a lot of matters that just stay at the state level, but it really depends on the matter. In the case of Asahi, you have, this case is particularly complicated because you had all these foreign defendants. And as soon as you start having all these defendants, you know, that could raise, you know, issues that are related to not just one state, number one, and number two, you know, according to the Supreme Court, you know, there's due process issues. You know, can you really subject foreign defendants to, you know, territorial jurisdiction, you know, just because they placed a product in the stream of commerce? So there's a number of questions that are that turned to be much more complicated, and that's why you have this line of cases before the U.S. Supreme Court. We are going to discuss a lot of this and fundamental issues in U.S. law. Okay, so I think this will become more clear as we move along. Any other questions on outlining before I actually turn into other topics? Any other questions? And remember, it's good to pick an outline and an outlining writing style that works for you and your style. So I'm giving you one example, but it doesn't mean that this is the example you have to use. I just want to give you an example so you have something to start thinking about what you could use. Okay, so let's move on to plagiarism. And now the conversation is going to turn very serious because for us at GW Law School, this is a major violation of our academic integrity code. It's probably one of the most important violations or basically problematic behaviors that you can have as a student. And a lot of students ask, why are you covering plagiarism? Why would anybody commit plagiarism? And I understand your question. You know, you're at the graduate level. Why would anybody do this? A lot of students do this. You know, there's a reason why we covered this in orientation, because unfortunately we do have a handful of students, you know, that commit plagiarism. So that's why we feel, you know, that we have to cover this topic. And I know that most of you are not going to do this, right? It's just that it's important to send the message that the consequences are very, very serious if you do commit plagiarism. You can be expelled from the school. You can be suspended from the school. You can actually have problems, you know, becoming a member of the bar, or you can be disbarred, you know, if you're caught committing plagiarism. So it's something that I want you to take very seriously. For us, plagiarism is representing the words, ideas, or text of another person as yours without proper citation. And I always tell students, the most important rule, if you don't get anything else out of this conversation, is if it's not yours, cite it. Cite it. You know, put it in quotes and cite it. If an idea is not yours, or even if you paraphrased it a little bit, you know, you want to put it in quotes and cite it. And you want to do this because for your own thoughts and your own writing, you would want somebody to be respectful towards you as well. Okay. Another thing about plagiarism that's very important is that you can commit it without intending to do so, you know, and this is where it gets very complex with students. You know, a lot of students are like, well, I didn't intend to do so. And we're like, well, unfortunately, you did commit plagiarism. So, you know, it can still be a problem, even if you don't intend to do so. So it's very important that you listen to what I'm saying right now, but also when you take legal research and writing 1, there's going to be a day devoted to plagiarism. It's very important that you take very seriously what your professor asks you to do. It can be unprofessional and career jeopardizing, aside from the academic consequences that it can have in the law school. I don't know if you followed, but there's been a number of cases in the US government of very high profile figures, you know, that they have lost positions, they have lost their reputation in the field, because of plagiarism. So it does have career consequences as well. And remember, if the language or the idea is not yours, use proper citation and identify the source. And this is even if you paraphrase. I always tell students, you know, a lot of students paraphrase and they think that because they're paraphrasing, they don't have to quote or cite. It is very important to still quote and cite and identify sources. And if in doubt, it's always good to use a quote and to identify sources, okay? Remember, and these are very important rules of thumb, you cannot copy another person's work word for word without citation. That's something that we prohibit at the law school. You need to put the language in quotation marks and the citation. Remember the paraphrasing and changing a few words. I would encourage you to look and read very carefully, you know, the document citing responsibly that was sent to you with this workshop. And it will also be asked, we will also ask you to read it as part of Legal Research and Writing 1. It's called Citing Responsibly, a guide to avoiding plagiarism, because it also gives you examples, you know, of what plagiarism can constitute. And if you are in doubt, ask me, ask your legal research and writing professor. Sometimes it's better to ask than to commit something without intending to do so, you know. Tips of how to avoid plagiarism. And this is all in Citing Responsibly in page 4, okay? Remember to always give full credit to borrowed ideas, words, and sources. Very important. If it's not yours, cite it and quote it. It's always good to, when you're working on a draft, many of you will be working on written submissions, to cite as you go. You know, a lot of students end up committing plagiarism by accident, you know, like they just, you know, they didn't do their citation, you know, as they went, so they forgot to include a cite. And for us, saying I didn't know is not a legitimate excuse. So it's a good idea to cite as you go, and also to give yourself enough time to review. And that's important as well, you know, when you're working on written work. And you will even have a plagiarism quiz in legal research and writing to make sure that you practice and you understand all of this fully. If you have doubts, you know, legal research and writing, you know, one of the things that we really teach you there is also proper citation form, you know, and if you try to cite, you won't be charged with plagiarism, you know. So if we see an effort to cite, even if the cite is not perfect, we won't, you know, we won't find that you committed plagiarism, you know. But it's good to start focusing on what proper citation form is, you know. I think this is good, especially for those of you that are going to be practicing in the legal field, you know, after this degree, or those of you that are already practicing in the legal field. And remember to always credit the source. This is extremely, extremely important. And it's okay if you have questions on plagiarism. It's okay to reach out to me. It's okay, you know, if you have any sort of questions, you know, and I think I saw a question in the chat about whether we have access to plagiarism software. You know, that's actually something that you can ask your legal research and writing professors or our foreign and research librarian, Tracy Emerson. But I would also get used to yourself, you know, doing the check as well. I trust more human beings than technology for things like plagiarism. So I would encourage you to do it yourself. As a lawyer, you're going to do so much writing. You know, I think that's what I've done the most as an attorney, writing. And it's good to get used to doing your own checkups, you know, and make sure that you always give credit and use citation where credit is due. Okay, I have questions. I have Kizang. Do you have a question, Kizang?
Yes, Dean. I was wondering if if I read a book and if I get some ideas and put it into my own words, would that lead to plagiarism?
That's plagiarism. That's plagiarism. Okay. It's a great question, right? Just make sure you credit the source, you know, especially if the ideas were extracted from the book, you know, they're not your own ideas. That needs to be quoted or cited, or at least an acknowledgement of the citation, the source, you know. I see Andrew.
Yeah, we use Scala in the United Kingdom. Which style guide are we using here at George Washington?
We use Blue Booking, the Blue Book.
That's new to me, so I need to learn that.
In Legal Research and Writing 1. Basically, we cover Blue Booking in Legal Research and Writing 1, which is the main citation style used by U.S. lawyers. You know, so you will have an entire class on Blue Book citation. So, and what I would focus on is making sure that citation is there, you know. Usually when we see plagiarism cases, it's not because the Blue Book citation wasn't correct. It's usually because there's no citation or quotation, you know? So focus more on getting used to citing everything, you know, that it was extracted, you know, from other material. Another kind of plagiarism that we see frequently, I'm not saying you're going to commit this or any of you are going to commit this, but a case, for example, that we saw last year that, you know, a student, you know, wrote a research paper and basically a lot of the research paper were paragraphs extracted from the internet and other articles, but there was absolutely no citation, no quotation, no acknowledgement, you know, of the sources, you know. And one thing that you should know is that we have a trained eye for plagiarism. Most of us read a lot of writing, so we can notice very quickly if there's plagiarism. So that's also something to think about. Your professors are very quick to find, you know, if you are using material that's not yours, you know. So keep that in mind. You know, it's good to get used to communicating your own ideas, your own analysis, and then you use quotation, you know, to basically supplement, you know, your ideas, you know, say, oh, this other author argued this, or, you know, but it's good to get used to using your own, you know, your own thinking in your papers, you know. Kazang, did you have another question?
I don't think.
Okay, and I'm looking at the chat to see if we have any other questions. Mustafa, do you have a question?
Yes, I do. In the UK, a large part of our research papers, like a large part of the points we received on our research papers were from showing research.
Mm-hmm.
So like one of my professors used to say, like 70% of your grade is showing tons of research. So I wonder if that's similar over here, because you know how you do legal writing, you get 1 point from one journal article compared to another, so on and so forth. That is, you know, it has the same level of value in the American academic system as it does in the UK.
Legal research is very important in our papers as well. However, what you don't see often is the rigidity in terms of the points. You know, it's not as if your professors are going to tell you, well, the paper is has to be 70% research, right? I mean, usually what you will see is a more integral evaluation of the paper as a whole. Like, for example, I teach research paper courses, and I usually I have a seminar grading sheet, you know, that the law school distributes, you know, that I distribute to my students so that they know what kind of elements I'm looking at in a paper. And I look at the quality of research, I look at the quality of legal argumentation, I look at structure, I look at the clarity of the premise. You know, I look at a lot of different components. I wouldn't say that I look at percentages of each, you know, I actually look at the paper as a whole. And a lot of the professors do that as well. I think I saw a question also about whether the Chicago style manual and the Blue Book were the same. They're not the same. They're actually different citation styles, and they're both very used, but in the US legal system, the preferred one is the Blue Booking. That's why that's the one that we teach in Legal Research 1, you know, for international students, because it's the one that you would use, for example, in law firms and legal employers in general, okay? I see that Andrew has a question. Do you have any other questions over there? No? Okay. I have Sharon.
Yes, I have a question. Is that if if the idea I think by myself is coincidentally very similar to others, and I don't realize it, whether it is plagiarism. You know, sometimes great people think alike.
Well, Sharon, you know what's the thing? That most ideas have been discussed beforehand. You know, you basically have to assume that most of what you're gonna say probably has some sources, you know? So I mentioned this because, especially for example, us as academics, we write a lot of law review articles, right? I write a lot of law review articles. And I advance a lot of creative ideas, but usually I cite to research that has alluded to anything even similar, you know? You can actually advance your own ideas, but also acknowledge that there's previous work, you know? And most of our ideas have been referred to at some point by someone, at least a component of the idea. So that's where the research comes in. You know, it's important to do your research, you know, and for example, I'll just give you an example. You know, I write a lot on climate change, right? So the phrase, the puzzle of climate change has been said by at least 100 entities already. You know what I mean? Like,
okay, got it.
So what I'm saying is, like, the fact that it's a good idea doesn't mean that it hasn't been referred to in some way. So you have to do, it's good to do research to make sure that whatever you are advocating for, you know, that at least your reader knows that you did your research, you know, that you did your research, and that even though your idea may be a little bit different, you know, you are aware that other thinkers have already advanced that idea in some way, right? But that you see it a little bit different because of blah, 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 right? So that's where the research comes in. But I always tell students, you have to assume that almost everything you think about, somebody has written about already. Okay. You know, it's only very, very few ideas that are true originals. And I'm not saying that you cannot give your own spin. You know, that's where the creativity comes in, right? You know, yeah. But it's very important to acknowledge that there's people that came before you that said it, right? And this can be, and also Sharon, one thing, you know, for me, when students are making arguments, especially because I teach research paper courses, they're much more convincing when they make the argument and then they say, for more analysis, see these sources. You know what I mean? Because I'm like, wow, they're making their own argument, but they also made all this research of like all these other people that are making similar arguments. So it also goes to the quality of your research, right? You know, but it's a good idea to assume that that most of your ideas have been mentioned or referred to in some way by someone else. You know?
Yeah, got it. Thank you.
Vanessa.
Hello, I have a question about the writing requirements, specifically about the research paper. When it's mentioned 8,000 words, it's like that 8,000 words, it's the cap or the minimum?
Minimum.
Minimum, okay.
It's the minimum, and that includes footnotes.
Oh, okay, okay. That was going to be my previous question, my next question, because the previous program I took, when word count was mentioned, it was like the maximum that we could write about that subject. So it's good to know that it's the minimum.
It's the minimum. It's the minimum to graduate. And remember that we have a number of research paper courses where you can do your writing requirement. You know, you can also do an independent legal writing as well.
Okay, perfect. Thank you.
And Destiny, I'm going to take her question and then we're going to move on to research papers. Okay, Destiny.
Hi. So my question is with regards to, would you recommend that it's better to have an overload of citations as opposed to like an underload?
Focus on quality.
Because clearly you
focus on quality. Like I always tell students, like including 20 citations that are not even related, for example, or just to show that you're a great researcher. I'm not sure, you know, I focus more on quality when I'm analyzing the citations, you know, focus on 2 or 3 very strong citations, you know, I see a lot of authors sometimes that you look at their papers and it's all citation, right?
Yeah.
And then when you start looking at the citation doesn't make much sense, you know? I would rather see more focused citation, 2 or 3, you know, and sources that are really, you know, and also it's good when you include your sources. You know, we have something in the US legal system that you include a parenthesis after the source, you know, in your footnote, basically referring to what it is or how it's related. And I think that can be very useful too. And that's very common in law review articles, you know?
Okay.
Yeah, and because it shows, you know, it shows that you included it for a purpose. There's a purpose or an objective behind including that citation, you know?
Okay.
And remember that you can always, and this is something that you will see with Blue Book, you can always introduce your citation, you know, you can see, for example, you know, like there's different ways of referring to citation as well for more discussion, you know? Like I think it's important to sometimes clarify why are you citing what you're citing, you know?
Okay, because I had that challenge in my previous master's program where we had to they emphasize, because you're not going to be the first to think about anything, about most things. So they really emphasize just cite it as much as possible. Just keep citing, because you're probably not the person who came up with that idea or that thought. So it's with regards to that I was wondering if it's good to
if you're in doubt, it's good to include a cite.
Okay.
I always tell students, like, you know, even if it's to say for more discussion, you know, like, you know, like it's a good idea to cite, you know, just to make sure that you don't fall into the plagiarism trap. I mean, you're very smart, you're all very capable. There's a reason, you know, you're in graduate school. So I always tell students, you know, trust your abilities, you know, like you don't need to refer to other people's work to make good arguments, you know? So just make sure that you know, that you're creative, but also that you give credit where credit is due, you know? Yeah.
Okay. Yes, thank you.
Welcome. So to close the seminar today, you know, I wanted to talk to you a little bit about research papers, because some of you are going to be in research paper courses, you know, and you know, I want to make sure that you understand the basics of these, you know, and some of you may come from, you know, undergrad legal degrees in which you did a lot of writing of papers, but some of you may come from jurisdictions in which this is the first time that you're writing a research paper. So I wanted to give you some pointers, you know. When you are asked to write a research paper in one of your courses at the law school, usually this is kind of like the structure that they're asking you to include. You know, they want you to include an introduction, they want you to include sections, they want you to include conclusions, you know, and in terms of that introduction, I always tell students, you know, that research papers, the introduction makes it or breaks it in many ways, because that's where you introduce your premise and what you're going to do in a specific paper. You explain the importance of your topic and why you chose it. You present your premise. You discuss sources of law and how you will apply them. And you also explain the structure of your paper. And then in those sections, that's where you advance your own legal analysis and arguments. And I think it's very important, especially in your sections, to get trained to use subtitles properly. It's always good to use subtitles. I always tell students, you know, especially students, you know, that have been trained in foreign schools, you know, this is a system that doesn't like very lengthy paragraphs, you know. Usually when we write in the US legal system, we write, you know, more, you know, shorter paragraphs, you know, for example, you know, and subtitles are good because you introduce your specific topic. Remember that it's always a combination of your own legal analysis and quoted material. Quoted material should never be most of your paper. So keep that in mind, you know. If you have a paper that is all quotes, you haven't really introduced your own ideas and analysis, and that's not really what you're being asked to do in a research paper. Usually when you are writing a research paper, you know, you are advancing your own legal analysis and arguments. And in terms of the conclusions, usually what you're being asked to do is to present insightful observations, to discuss the future implications of a topic and the recommendations. And I think with research papers, what I always tell students is like, make sure that you focus more on the clarity, you know, the clarity of your ideas, premise, proposition, and arguments, you know, more so than anything, you know. And I see some hands raised, so I want to give you the opportunity to ask questions before we actually close for today. Destiny, do you have questions?
Oh, no, that's fine. I'm sorry. I just forgot to put my hand down.
That's okay. And I see Myra.
Yeah, hello. I have one question regarding the introduction. I mean, probably we're gonna go more in depth during the legal writing class, but in the introduction, I see that you only have to present your premise, and I was wondering if we also have to do sort of the legal question.
Yes, you describe your legal question. Your introduction is basically what you're presenting to the reader, what you're about to do. So you present your legal question, your premise, your main idea, the sources that you're going to be using. I always like when students, for example, describe the structure of your paper, you know, how the sections are connected, how the introduction and conclusions are connected, you know, that's the place where you really introduce your paper. And it's a very important place because if your reader doesn't understand what you're trying to do, it's going to be very difficult to read the rest of the paper, you know. I think it's a very important section. You know, for me, it's the most important section of a paper in many ways, you know.
Okay, thank you.
You're welcome. And let me see if there's any other questions. I just want to make sure you have an opportunity here. I have Andrew.
Okay, go ahead.
Yeah, just one comment. My dissertation in the UK was about 10,000 words, and in the UK they actually run all essays through software. They check all worldwide internet and books and everything, and so they do capture, you know, what was quoted and what was plagiarized. Anyway, on my dissertation, it was about 45% was actual quoted, but it was all cited and footnoted and very thoroughly, maybe with 100 different citations. That's just the point. I'm following what you're saying. I've never used Blue Book, so I'm going to have to learn Blue Book.
That's something we're going to teach you to do. That's something that we teach you to do in legal research and writing. And what I mean by quotes is that sometimes students, you know, especially students that haven't had experience writing research papers, they just pull quotes from the internet and they put them in the paper, you know, without including their own analysis of the issue, you know, and that's not a paper. And I mention it because we've seen a number of students do that, you know. I get the sense from what you're telling me about your dissertation that that's not what you did, right? That you did your analysis, right? And you supplemented it with quotes and citation, and that's normal. That's normal to do in a research paper. I'm referring more to papers that we have seen that they're just a collection of quotes from the internet. And that's not a research paper. A research paper is your own ideas and analysis of a specific topic, and you can use quotes and citation to complement, to show that you've done your research, etc. But it's not supposed to just be a collection of quotes.
Go ahead. We have another question.
What is the view of citing from a lecture or from a professor, either from the class in question or from another class?
I'm sorry, I didn't hear you. Can you please repeat your question?
I think his question was, this is Andrew here. This question was the view of citing in one class other classes that you're taking, other like your professors and other.
I don't think that's a good idea. I don't think that's a good idea. It's not very respectful towards your professor, you know? Like I would do research outside of, you know, like I don't think your professors would like that very much, you know? I think it's better to use your own research of, you know, legal sources. And if you're in doubt, we have this wonderful research and foreign law librarian, Tracy Emerson, who can always guide you in terms of research. She's going to give some research training and legal research and writing one. But for me, if a student cites another class, that's not very creative. I don't know. I actually don't. It's not something that I would feel very comfortable with. And I have a feeling most of our professors wouldn't. So it's not something that I would do. And I have Mustafa.
Yeah, I just wanted to see whether we have access to LexisNexis and Westlaw.
You do. Yes, you do. And Tracy Emerson you know, from the library is going to help facilitate that. And she's actually going to give a training on library research on September 17th. This is going to be part of your legal research and writing course. And also you will have Lexis and Nexus training on October 1st. So you definitely have access. And I'm not sure whether you have that access yet. Andrew may have the answer to that question. But we will definitely train you of how to use Lexis and Nexus, and you will get access as well. It's one of the main research sources that we have. So it's a great question, and you will definitely have access to that.
Thank you.
Of course. And Destiny has the last question before we close this workshop.
Okay, so I was wondering, is it okay to cite, so say I read one of your work, and is it okay for me to cite that, even though I'm in another class? But it's something that's relevant, something you wrote.
Well, if it's a law review article, for example, what I think it's complicated is to cite the notes or what another professor said in class in another class.
Okay.
If it's an article, that's something else. If it's a book, that's something else, right?
Okay.
But like what I find strange is like, imagine if we have two constitutional law professors and one of them interprets the Constitution in one way and the case in one way, and the other one interprets it another way to cite the other one. It's kind of like,
yeah,
that's not something that I would do in a class, you know, but articles is different. If you want to cite articles or books, or of course, that's research, right?
Okay.
But I would refrain, you know, from doing anything. I always tell students that it's a great idea to get along with your professors. You know what I mean? You want to be respectful. You want to be, you want your professors to have a good impression of you. You know, they're your ultimate graders. You know, they can be your mentors. You know, your professors can help you in the future. So you want to create a good impression with them, and you want to respect them as well. You know, so I think it's important to do that as well. You know, so keep that in mind. But I think citing an article or a book, or professors love seeing their work cited. You know, so I think that's different than, you know, like I'll give you an example. You know, I teach my courses. You know, if a student says, "Well, this other professor said this in this class, and he disagrees with you," it's kind of like, "Well, you're in my class." You know? I always tell students, you know, well, you know, you decided my class, you know, so I think there's basic respect rules that it's important to keep in mind with your professors. Remember that a lot of your professors too are very well-known experts in their areas, you know, so keep that in mind as well, you know.
Okay, thank you.
You're welcome. Any other questions before we close for today? I hope this was useful to all of you. It's wonderful to be working with you. For those of you that are pursuing fundamental issues in US law with me, with my class, we will see each other again next Tuesday, starting at 10 in the morning in Learner 401. Remember that there's two different sections of fundamentals. There's mine, and there's the one taught by Professor Robin Chan. That section starts instead, you know, the week of August 30th on Thursday at 7 in the evening, which would be August 26th. Remember that if you have joined Professor Chan's section, you do not have to meet with me next week, because basically my class is the one that starts next week. Professor Chan starts the week of August 30th. I look forward to seeing all of you in my class, and I hope you have a wonderful week next week since you start your classes. Remember that I'm always available if you have any questions. I love working with graduate students, so feel free to reach out. I think you asked a lot of really great questions, you know, and it's great to be spending time with you, and I wish you the best of luck as you navigate this semester. Okay? And I hope you have a good rest of the orientation, because I know you're still in the orientation, okay? So I will, and I will see, I think, a good segment of you next week. So it's great to continue being in touch. Okay, have a good day.
Thank you very much. Have a good one.
Thank you.
Thank you.
Thank you.
Thank you.
Bye-bye. Bye.
Bye, and have a good rest of the day. I know you're busy.